Greetings to one and all. You are listening to MMJC podcast. In this edition, we will be discussing about amendments to companies' rules and orders issued by ROC and NCLT. The first update pertains to amendments. On 19th May 2025, Ministry of Corporate Affairs has amended Rule 12, Sub-Rule 1B of the Companies Accounts Rule 2040. Through this amendment, MCA has changed the due dates for filing Form CSR2 from 31st March 2025 to 30th June 2025. This due date pertains to filing of form for financial year 23-24. That means Form CSR2 giving information about CSR spending for financial year 23-24 can be filed up to June 30th, 2025. Next update pertains to orders.
So the first order for today is an adjudication order issued by ROC Ernakulam, and it pertains to violation of Section 90 of Companies Act 2013. So Section 90 requires the companies and its shareholders to give declaration about significant beneficial ownership of shares held by the members. So in this case, the company had two significant beneficial owners since 1998. And as a result, after coming into force of significant beneficial ownership rules, the company was required to give declaration about the same. However, the company sent notice to its shareholders asking about holding of significant beneficial ownership in a delay, and as a result, declaration from members was also received in a delay. Further, the form intimating ROC about such significant beneficial ownership was also filed by the company after a considerable delay. As a result, ROC imposed penalty of on the company, its directors, and also on the shareholders who are the significant beneficial owners. Other non-compliances observed in Section 90 can be summarized from the orders issued by ROC across the country in year 24-25. Approximately 85 orders were issued by ROC during this financial year. So the Section 90 says that company should send a notice to the members about whom the company believes that they hold significant beneficial ownership in the company. On receipt of such notice, the members are required to give declaration in Form Ben 1 if they hold such ownership. And on receipt of Form Ben 1, the company should intimate ROC about the significant beneficial ownership of the specific members in Form Ben 2. This has to be done within 30 days from receipt of Form Ben 1. The non-compliances mainly observed are that the companies do not send notices to the relevant members whom they believe to have significant beneficial ownership. Also, the members fail to give declarations about their ownership, significant beneficial ownership in the company. Also, it is observed that at times declarations are received from the members, but the form filing with ROC is done by the company in a delay. So the companies, to avoid penalties, can take care that they are sending notices periodically to such members whom they believe to be the significant beneficial owners, and forms received from members in the form of declaration are filed with ROC in time. The next order is issued by NCLT. So this order is under Section 73, subsection 4, read with Rule 2, 1, Clause C, subclause 12, which is the definition of deposits. So in this case, what had happened was the petitioner, who was a partnership firm, was buying goods from the company, respondent company, and as a practice, they had given some advance money to the respondent company for supply of goods. However, even after passing of 1 year, the goods for which the advance was given were not received. Therefore, the partnership firm was before NCLT praying that the said advance given to the company should be treated as deposit, and the company should be ordered to refund the same along with interest. However, the NCLT explained that As per Rule 21C 12, Para A, advance received can be treated as deposit if it is not refunded, or it is not, if it is not appropriated against any particular supply of goods or services for 365 days. However, if the advance received is specifically relates to any particular supply of goods or services, and it is not intended to be refunded, then it cannot be treated as deposit. For treating an advance as deposit, it is necessary that it is not particularly marked against supply of any particular goods or services. So that is all in this edition of MMJC podcast. Thank you for listening to us. Please feel free to write to us about your feedbacks.